Assistant Public Defender Chelsea Regals with and on behalf of Sirino Johnson. Mr. Johnson, please state your name.
Sirino Johnson.
I mispronounce your name every time, so I apologize.
Thank you, Your Honor. Today
All right, folks. The courtroom's heating up fast. Probable cause conference time, which basically means the court's about to decide if there's enough reason to keep things moving. And guess what? Johnson just walked in with confession ready, but not without a twist.
is the time and date for a probable cause conference. Regarding that, we are asking for an adjournment to show compliance with his bond conditions. I understand he's had a violation that we are prepared to deal with today.
All right.
Mr. Johnson is prepared to plead guilty to violating his bond by consuming alcohol on July 7th.
Oh. And I'll accept that. Before imposing any sentence regarding that, I'm going to ask this question. He has indicated that he had old duels. So my only question is, does your client wish to stick to that story, or does he wish to tell me the truth?
I believe that he would not be sticking to that story, that he would be stating that he consumed beer.
That's correct, Your Honor.
Hold up. This man really tried to slide past the system with a non-alcoholic beer defense. But the judge? Not buying it for a second. This is classic. When lies unravel faster than your bond agreement.
And why'd you tell everybody old duels?
I had old duels first, but I needed beer.
You had old...
Yeah. I don't look like one of them.
No.
I had old duels.
Are
but
you
I had
tell me that? So did you tell them that?
Yes.
That you had old duels first, and then had beer?
Maybe I omitted beers, but yes.
What?
I omitted.
Hold it. You know what, sir? Don't play fast and loose.
I got the story. I consume alcohol.
I know that.
You lied to them.
Did you even have any duels that day?
Yes.
How many?
6.
And then how many beers?
2.
So why didn't you tell them that you had the beer?
I just omitted.
Pardon?
I just didn't. I was afraid of what might happen. I thought I could pass.
Yeah, I would be too. Because you're violating your bond condition.
Indeed.
So, first of all, we did the calculation because the only story you gave is that you had old duels. To get to the level that you were at, you would have had to have 25 old duels in an hour in order to reach that level. And could not have used the bathroom because you couldn't eliminate in order to get to that level.
Ouch. Judge came in scorching hot. Did you catch that math? 25 Odell less in an hour with no bathroom breaks. Talk about calling BS with precision. If you're gonna lie, at least make it remotely believable.
That's how stupid your story was. And now you can't even... You can't bring yourself to say that you were intentionally lying to them and attempting to mislead them. It was not just a simple omission. Counsel, what did you want me to do with this case?
And regarding the probable cause conference, we're asking for a 2-week adjournment so that he can show that he's going to comply with the court's orders. I understand.
Well, I don't think he's going to have a choice on that, quite frankly. Mr.
Yeah.
Allen.
We are asking for him to remain out of custody today. This would be his first bond violation He is here to be honest with you, although the truth doesn't always make sense.
Really?
He is.
And there it is. Defense tries to spin the honesty and redemption narrative, but the judge ain't falling for courtroom fairy tales. Viewers, do you think he deserves another shot at freedom? Drop your take in the comments below.
Really?
He's here.
No, he was not being honest. I asked him the question, and then asked him the question of why didn't he tell them, and he couldn't even be honest about that. I'll let you go ahead with your argument, but I'm not buying any of it.
Your Honor, he is honest about the fact that he consumed alcohol, and he is very open to treatment. He understands that he has a substance issue and he wants to get help for that. Your Honor, he's a business owner. There's a lot of pressure on him. He provides for himself and his family. He also does volunteer work, not court ordered, just out of the goodness of his heart. He is open to treatment, substance abuse counseling. He plans to seek that regardless of whether the court orders it or not. We're asking you to keep him out of custody with a scram tether. Again, this would be his first violation, and he's asking for the opportunity to show compliance while out of custody.
Anything from the people?
Your Honor, we do have concern about Mr. Johnson's ability to comply with the bond conditions. As stated, this is his second offense. His and I think it's just a couple of years. We would note that in this case, he allegedly was not awake that was in the street with 2 guns on him, although he's only charged with 1 CCW. So we do have some concerns about whether he's able to comply with those bond conditions.
Anything else?
Your Honor, I just think that he would have a better opportunity to get the treatment and help that he needs out of custody.
He first has to admit that he has a problem.
I
The
do.
way that he does admit that is he stops lying. Defendant's bond at this time is revoked. Defendant's remaining.
Anna Mackey on behalf of Mr. Haywood, who is approaching to my right. Please state your name for the record.
Good morning, Your Honor. Ron Hayward.
And I believe we reached a resolution in this matter.
You have. And it's here. That's right. This is the one that. Hang on. Sure, this is the one that I did. All right. We have a plea form in this case. The defendant would be pleading to the charge of use of a controlled substance. I don't have. How come these forms aren't that hard to fill out?
Pardon?
How come I don't have the maximum penalty of what he's pleading to? Who did?
Welcome to the comedy portion of court, where filling out a plea form turns into a group project no one wants to claim. Honestly, you'd think they were confessing to cheating on a school exam.
This, Mr. Childers. Mr. Childers,
I
type. Childers, you know what? No, you know what? It's typed. Did you type it?
No, I did.
You didn't. Who did?
It was a group effort, but I'll take it.
I appreciate Ms. Mackey because she provided me the basic law. This is a book. I think we're both involved here.
It just felt.
Provided me that they mostly typed out the form. All I did was look at it, sign it, and send it back to her.
Because if it was up to me.
It's not myself. I
Correct.
appreciate Ms. Mackey doing my work for me. I'm not gonna stop there.
So she hand did it.
So we both-
I wasn't going to put a max penalty for my client.
What?
It felt wrong until you could do that part. So I was like,
That hurt. I just couldn't write that. I couldn't type that part. What is the maximum penalty on the one? Pardon? 1 year, 2,000. It was a group effort. I like how they all sat there and tried to protect each other. All right. May I have him sworn?
solemnly sworn to affirm the testimony you're about to give the truth, the whole truth. So help you God.
I do.
State your name.
Devon Hayward.
All right. Sir, it is this court's understanding that you are going to be pleading no contest to the charge of use of a controlled substance. That's a misdemeanor, punishable by up to 1 year incarceration and $2,000 fine plus court costs. Do you understand that, sir?
I do, Your Honor.
You understand what a no contest plea is?
Yes, I do, Your Honor.
All right, 2 things about it I have to make sure that you understand. First thing is that it means that you're not further desirous or wanting to contest this charge. You understand that?
I do.
Second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
I understand.
You understand also, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Washington in the 14B District Court. You understand that?
I do.
All right. Basis for the no contest plea.
Civil liability, Your Honor.
All right. And sir, to this charge, how do you plead?
No contest.
Now you understand that by pleading no contest, you will not have a trial of any kind.
I do.
You signed an advice of rights form, is that correct, sir?
Yes, sir, Your Honor.
Do you have any question regarding any of those rights?
No, sir, Your
All right. Please look at paragraph 5 on that form. You'll see a copy on the podium. Those are your rights which are part of the trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights of man.
Honor. Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
I am. I'm on probation. Explain the case.
Well, were you on probation at the time of this event?
No, Your Honor.
All right.
No, Your Honor.
Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
No, Your Honor.
Has anybody threatened you or coerced you?
No, Your Honor.
You're doing this voluntarily
Yes, sir.
and of your own free will.
Yes, sir.
Court has been provided Washington County Sheriff's Office report, and I've also reviewed that report for their case number 2442704. Any objection to the court having reviewed that report?
None from us, Your Honor.
Sir, you also understand that if between the time I accept your plea, if I accept your plea, and the time of sentencing, if you commit misconduct as defined by the court rule, two things would occur. You would not be entitled to set aside your plea, and the court would not be bound by any sentence agreement and or evaluation of your case. You understand?
This is the part most defendants tune out, but it's crucial. Once you plead no contest, any misconduct before sentencing means boom. The court can throw the deal out. No takebacks. You think that's fair or too harsh?
I do.
All right. Based upon the review of that report, the court does find that there is a sufficient factual basis in which the court could determine the defendant's guilt. Before I accept his plea, is counsel aware of any other promises, threats, or other inducements which have caused this plea?
Out of it.
None, Your Honor.
All right. The court will accept the defendant's plea of no contest to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14B probation. Sentencing in this matter will be August 14, 2025. What time? 10 a.m. before Judge Washington. Bond will continue.
Thank you, Your Honor.
Thank you.
Thank you. Thank you, sir. Court calls the case, People versus Derek Stevens.